Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Wednesday, June 13, 2018. The time is approximately 9:05 a.m. and we are meeting in the hearing board room in Diamond Bar. We have one matter on the calendar for today, and that is SCAQMD versus Sheraton Townhouse LP, case number 6106-1 for order for abatement. Who is representing the executive officer today?
Daphne Seaford, executive officer.
Thank you. And who is representing Sheraton Townhouse?
Sage Stone for Sheraton Townhouse.
And Mr. Stone, can you spell your name for the record? We keep a recording. I'm sorry. We start over. Okay. Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Wednesday, June 13, 2018. The time is approximately 9:05 a.m. and we are meeting in the hearing board room in Diamond Bar. We have one matter on the calendar for today, and that is SCAQMD versus Sheraton Townhouse LP, case number 6106-1. And I will again ask, who is representing the executive officer today?
Daphne Seaford, executive officer.
Thank you, Ms. Sue. And who is representing Sheraton Townhouse? And if you could both spell your name for the record, and also indicate your title and who you're with.
My name is Sage Stone. I'm an attorney with Kimball, Tyree, St. John, and we're representing Sheraton Townhouse LP. My name is spelled S-A-G-E, last name S-T-O-N-E.
Thank you, Mr. Stone. We're going to take maybe 5 minutes off the record just to complete, so that all the board members, unless you already have board members, do you need about 5 minutes to review the findings and decision? Yes. We just received it this morning, and so we're going to take 5 to 10 minutes to just finish reviewing the stipulated order for abatement, findings, and decision. And so we're going to go off the record.
Test 1, 2. Yes, it's recording now. Okay.
We are back on the record. We have to do that one more time. Apparently, it did not record yet again, so here we go. The hearing board of the South Coast Air Quality Management District is in session. Today is Wednesday, June 13, 2018. The time now is just after 9:10 a.m., and we are meeting in the hearing board room in Diamond Bar. We have one matter on the calendar today, and that is SCAQMD versus Sheraton Townhouse LP, case number 6106-1 for an order for abatement. I'm going to ask again who's representing the executive officer.
Daphne Seaford, Executive Officer.
Thank you. And who is representing the Sheraton Townhouse? And I apologize, Mr. Stone, you will have to spell your name and state your title again.
Sage Stone, S-A-G-E, last name S-T-O-N-E, attorney for Sheraton Townhouse LP.
Thank you. And I'm going to ask anyone who may testify in today's matter to please rise to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Okay. Ms. Sue, I'm going to ask you for your opening today.
Good morning, Chair and members of the board. The district petitions the hearing board for an order for abatement directed at Sheraton Townhouse. Sheraton Townhouse is an apartment complex located in Los Angeles. It is committing several violations. First, it is operating 4 boilers without demonstrating compliance with emissions limits in violation of Rule 1146.2. The rule provides emissions limits for nitrogen oxides and for carbon monoxide. The rule requires boilers older than 15 years old to be modified or demonstrated to meet emissions limits. Second, the 4 boilers have not been registered as required by Rule 222. Third, it is operating an emergency internal combustion engine without a valid permit to operate in violation of Rule 203 and in violation of Rule 1470 emissions limits. The district and the facility have stipulated to a proposed order. We request that the hearing board enter the proposed order. We have here today Jessica Torres, an inspector with AQMD, who will testify regarding the violations, and Mr. Sidney Baker, an engineer with AQMD, who will testify regarding emissions limits of the internal combustion engine. Thank you.
Thank you, Ms. Sue. Mr. Stone, if you'd like to give a brief opening statement as to your position.
Thank you. Sheraton Townhomes is a 14-story affordable housing community located in a historic building in the central area of Los Angeles. It's an affordable housing building. Rents are maintained well below market rate and are strictly regulated by law. In undertaking capital projects to renovate the property, the client cannot simply raise funding by increasing rents. It has to obtain funding outside of its own building. In 2012, the building recently got out of the rent escrow account program, which is a process undertaken by the city of Los Angeles that takes the rents paid into an escrow account when there's serious health or habitability issues. In 2012, the client paid over $2 million out of its own funds to renovate the building to make sure the building complied with all health and habitability standards and to remove the building out of the REIT program. In April 2013, the South Coast Air Quality Management District issued a citation finding that the emergency generator, the internal combustion engine, lacked a permit to operate. At the time the notice was received, the client was in the throes of dealing with heavy repairs being made to the property. My client here, who's represented by Rocio Galvez and Nolita Contreras when she arrives, will testify that the citation, nobody really knows what happened with it, unfortunately. And the citation became out of sight and out of mind when no further inspections were conducted and no further correspondence was received, which led the client to believe that the matter had been resolved. In addition, with regard to other capital projects affecting the habitability of the building, in the end of 2014, the client had to go undertake a major elevator renovation project for its 14-story building to ensure that all the elevators were working in accordance with all applicable standards. The client has paid up to, over $400,000 to this point to renovate the elevator building as well. With regard to this citation at issue here, the inspector will testify, according to the petition, that he visited the client visited the building in December 2014 and found that the boilers were outdated and needed retrofitting, and also that the emergency generator, which generates more power than 50 horsepower, lacked a permit to operate. And they issued a notice saying as much, that the building was in violation of District Rule 203A and 1146.2. On April 18th, 2018, Council for the Air Quality Management District sent a letter to Sheraton Townhomes asking for a response by May 17th, 2018. They went ahead and filed a petition on May 2nd, 2018. And the petition at that time cited rules violations in accordance with the notice in December, violating that Sheraton Townhomes was violating rules 203A and 1146.2. You'll hear today that when Sheraton received the letter, they immediately contacted contractors to get in compliance. They were able to obtain bids, and the contractors actually informed them at that time that the boilers would need to be replaced. There was no possible way to retrofit them. And the cost of the project would be $70,000 to replace all 4 boilers. Through council, the client responds on May 21st after the petition has been filed, indicating the situation and that they were amenable to stipulating. But then on June 1st, 2018, the Air Quality Management District, through council, amended its petition to add 2 more violations. And we hadn't received notice of those violations until we actually received the petition last week. Those were for violation of District Rule 222 and 1470. This presents some really due process concerns. Most notably being that there was no notice of the violations until last week, June 1st. The petition was filed on June 1st, it was served by mail, and it was received within the time period of June 1st to June 5th. Sheraton Townhouse simply has not had enough time to comply with the new violations with regard to District Rule 222 and 1470 because we haven't received notice of these violations. Constitutional due process requires that with regard for any taking of property, there has to be notice and an opportunity to be heard. Sheraton Townhomes has not had any notice with regard to these violations until June 1st. And in fact, Sheraton Townhomes did not receive bids on replacing the emergency internal combustion engine when it received bids to replace the boilers because of this problem. It is only recently, since last week, we were informed of this problem that Sheraton Townhomes has had an opportunity to even contact anyone and not even an opportunity for them to visit the property. You'll hear from Ms. Galvez that the only time any contractors were able to visit the property to remedy this issue is next week, after this hearing. Either this hearing is premature or there's simply just a lack of notice, the appropriate notice for constitutional due process guarantees to prosecute a violation of District Rule 222 or District Rule 1470. That being said, in good faith, Sheraton Townhomes has negotiated a stipulation with council that we're willing to enter into that a client believes that they can follow, with the understanding that we can modify should our timing on the, specifically on the internal combustion engine, become an issue. Our client has received bids for the work on the internal combustion engine to take 4 to 6 weeks, but the client believes that it is possible we can possibly get this done in 21 days after receiving a permit to do the actual work. Thank you.
Thank you. Mr. Stone, I had just a couple questions based on your opening. I understand that you ended your opening by stating that you have agreed to the stipulation, but you did question due process and any violations that were amended or added to the petition of which you received notice first on June 1st. You are aware, though, and I assume your client is aware, that a stipulated order for abatement, this hearing board is not required to find violation. Are you aware of that?
Yes, Your Honor, and excuse me, I'm so used to saying Your Honor.
It's
excuse
fine.
me. Yes, I am aware. And in fact, I believe in the stipulation, we've negotiated the language to not really admit any. I think we're just agreeing to go forward with the remedies in the order.
Okay, so your client is on board with the stipulated order for abatement?
Yes.
Okay. The other thing I wanted to make sure is clear, having read the proposed stipulated order for abatement, I do notice that quite unusual to add in here a provision of allowing, and I know you mentioned it, allowing the respondent to seek modification if they cannot comply with the schedule. That is unorthodox. We can talk about that during the hearing and deliberation. It's always allowed by the rules, as long as it's done in a timely manner. But I want to make sure that you and your client understand that regardless of whether this order is accepted as proposed, there is never a given that you can, in fact, modify. You would have to come before the hearing board, and the hearing board would have to determine good cause to modify. Are you aware of that?
We are aware of that. The timeline agreed to was just simply the best that we could get from council. We would ask for more time if that's an option, just at the outset without having to modify. It's just simply because we don't have the amount of time that our contractors estimate already that the project would take.
Okay, I'm gonna stop you there, and we'll let that come through during testimony. But I just wanted to make sure that you were aware that as a legal matter, we would not grant any order that would automatically entitle anyone to a modification.
Yes, I understand that.
Okay, thank you. And then the last question I have for you is, you mentioned you're going to have another witness. Do you have a necessary witness that will be here at a certain time that perhaps we should make sure arrives in time?
Yes, we have one other witness. She actually lives on the property. Her name is Nolita Contreras. She should be here any minute. We were told that she'd be here within 10 minutes, about 10 minutes ago.
Okay.
So,
Is it necessary that she be here for the full hearing, or she's just here to provide additional evidence?
it's not necessary for her to be here for the full hearing.
Okay.
We can proceed.
Okay, thank you. Okay, Ms. Sue, let's start with your first witness.
Good morning, Ms. Torres. Please state and spell your name for the record.
Jessica Torres, Jessica, last name Torres.
And did you take the oath this morning?
Yes.
And what is your title here at the district?
Air Quality Inspector 1,
And how long have you worked in this position?
about 14 months.
And could you please briefly describe your responsibilities?
My responsibilities are to inspect facilities and determine compliance with AQMD rules.
And have you reviewed the petition in this matter?
Yes.
Are you familiar with the respondent?
Yes.
And what type of facility is Sheraton Townhouse?
An apartment complex.
Have you inspected Sheraton Townhouse?
Yes.
And what dates were these inspections?
December 5th, 2017 and December 8th, 2017.
And did you observe boilers at this property?
Yes.
And how many?
4.
And where were these boilers?
2 were in the basement and 2 were on the roof.
And what were the serial numbers?
The serial numbers for the 2 in the basement are C98H02906 and C98H02905. The 2 on the roof are C97J06841 and C97J07278.
And on December 5th, 2017, did you observe any of these boilers operating?
Yes, 3 of them.
Okay, and where were they located?
2 in the basement and 1 on the roof.
And on December 8th, 2017, did you observe any of the boilers operating?
Yes, the other one on the roof.
Okay, and what type of boilers are these?
They are Teledyne Lars boilers rated at 1.01 million BTU.
And and are you familiar with 1146.2?
Yes,
And what is the purpose of Rule 1146.2?
to reduce emissions from boilers.
And what is the emissions limits that applies to these boilers?
For these boilers, 30 ppm of NOx and 400 ppm of carbon monoxide.
And do these limits apply to Sheraton's boilers based on their age?
Yes.
And how do you know when Sheraton's townhouse boilers were manufactured?
The serial number references the date of manufacture.
And when were they manufactured?
The 2 in the basement were manufactured in 1998 and the 2 on the roof in 97.
And how can a unit meet the requirements of Rule 1146.2E?
They can be certified, have a certified retrofit kit installed, or have a source test done.
And has any of these 4 boilers been certified?
No.
And how do you know this?
I compared the model number of the boilers to our certified list, and they were not on them.
And has a certified retrofit kit been installed on any of these 4 boilers?
No.
And how do you know this?
There was no certified retrokit plate on the boilers.
And has the district received a source test report that shows compliance with the emissions limits for any of these 4 boilers?
No.
Are you familiar with Rule 222?
Yes.
And what is the purpose of Rule 222?
For equipment that does not need a permit so that they can be registered with the district.
Okay, and does the rule require owners to register boilers between 1 million and 2 million BTU per hour?
Yes.
And are these 4 boilers subject to this rule?
Yes.
And has a registration plan been submitted for these 4 boilers?
No.
Have you reviewed the stipulated proposed order?
Yes.
And do the proposed replacement boilers require a registration plan?
No.
And why do they not require a registration plan?
They are under 1 million BTU.
And now turning to the subject of the internal combustion engine, during your inspection on December 5th, 2017, did you see a generator?
Yes.
And did you see a serial number on this generator?
Yes.
And what is its serial number?
2041425.
And is an internal combustion engine a part of the generator?
Yes.
And what is its rating and brake horsepower?
208.
And how has the engine been has the engine been operated without an active permit?
Yes.
And how do you know this?
I compared the hour meter reading that I saw on the day of the inspection with the hour meter reading of the previous inspection in 2013, and I saw a difference of more than 55 hours.
Are you aware that a notice of violation was issued in 2013 for lack of a permit to operate this engine?
Yes.
And what was the resolution of this notice of violation?
The facility informed the inspector at that time that they were no longer going to be using the equipment.
Okay, and are you familiar with District Rule 203?
Yes.
And what is that rule?
Requires equipment to have a permit.
And does that, Rule 203, does that apply to the internal combustion engine?
Yes.
Okay. And how close is this engine to a school?
Within 100 feet.
And how do you know this?
Objection, called lack of foundation.
Well, I was going to ask her, how does she know this?
Okay, thank you. Objection is sustained, and let's lay the foundation.
Oh, how do you, have you investigated how far the generator is from the school?
Yes.
And how did you perform this investigation?
I used Google Maps for a rough estimate of from the exhaust stack to a rough estimate of the school property. Google Maps told me that it was about 80 feet.
Objection, lack of personal knowledge, calls for expert opinion. A lack of hearsay evidence based on Google Maps.
I'm going to overrule the objection and let you know that this board does not, we can admit hearsay evidence, although we cannot base any one finding completely on hearsay evidence. And we'll just take Google Maps for what it's worth. At least we'll take the testimony that she looked at Google Maps, and that's what Google Maps said. You may continue.
Thank you. No further questions for Ms. Torres at this time.
Mr. Stone, do you have any questions for the witness?
Yes, I do. Ms. Torres, did you issue a notice of violation in this case?
Yes.
And that was on December 5th, 2017. Is that right?
I issued the violation on December 8th.
Okay. And the violations you listed were 203A and 1146.2. Is that right?
Yes.
Did you list a violation for 1470?
No.
Why not?
The issue that we had was with the lack of a permit.
Okay. Did you measure the distance between the internal combustion engine and the school?
Not physically.
Okay, so you just relied on Google Maps.
Yes.
Did you type in the address of the school on Google Maps?
Yes.
Okay, and did you observe where the physical address is on Google Maps?
Yes.
And did you observe the actual comparison of where that point was with the actual school?
Can you restate that?
Sure. Did you actually see the school?
Yes.
Did you compare where Google Maps listed the address for the school and where it actually was?
Yes.
Okay, and what was the address of the school?
I believe I'm recalling from memory it's 631. Let me find the street name. Commonwealth?
Okay. And did it seem like that corresponded with the Google Maps location?
Yes.
Okay. That's all.
Thank you. Mr. Camarena, questions?
Thank you. Ms. Torres, in your testimony, you talked about a prior inspection in 2013. Were there any inspections between 2013 and your inspection in 2017?
No.
Do you know the violation notice number for well, it doesn't say in the petition nor in the proposed findings that a notice of violation was issued. It says district cited the facility. Do you know how that citation was done? Was it by notice of violation, notice to comply, or some other method?
Yeah, so notice of violation P58188 was issued in 2013, on March 13th, 2013.
What was the notice number again?
P58188.
Is there a district policy for following up on notices of violation to see if the source has come into compliance?
I'm not aware of a certain policy, but that is routine to follow up on them.
Do you know why there was no follow-up to the notice issued in 2013?
I believe the follow-up was the facility stating that they weren't going to be using the equipment anymore,
Was that verified?
other than the inspection report.
Do you know when I see the internal combustion engine on the emergency generator was installed?
The earliest date that I have was when the permit was issued in July 17th, 2002.
So it does have a permit?
It did have a permit at one point, but it was let to go inactive, marked inactive, non-renewable on March 19th, 2012.
And then after that, doesn't stay inactive forever?
Yes, it stays inactive once it goes inactive, non-renewable.
Okay, and that was non-renewable when?
March 19th, 2012.
In the petition, it says that on December 8th, the district notified them of the 203A and 1146.2 violations. Were they also notified at that time of the 1470 violation?
No,
And the reason?
just because we weren't citing it at the time.
You weren't?
We weren't citing that in the violation at that time.
But it was in effect at that time.
The emissions limits were in effect. We also couldn't verify any operation during school hours since the facility didn't know how to obtain those records, and they weren't keeping the records on their own.
Okay. I have no other questions.
I have just one question. What is the usual method that the district relies upon to determine distance between a facility and a school, if you know?
We have measuring sticks, or usually a rough estimate is acceptable with Google Maps in our reports.
Okay, so you do have physical ability to measure, but also Google Maps is generally acceptable?
To give a very rough estimate, if it comes into question and we do need to get a better measurement, then we can measure physically.
Okay. Thank you. Other questions, board members? Ms. Byrd?
I just wanted to confirm with the two NOVs. You said one was issued March 13th, 2013, and then the other one was issued 12/8/2017. Is that correct?
Yes.
They were issued for the same one? The first one was issued just for lack of permit, or do you have?
It also included the boilers, but I believe it only referenced the two in the basement.
And that was for what?
For also,
What was the violation?
to also, a failure also to demonstrate compliance with the emissions limits.
Okay. And then the one in 2017 was for these same items?
Yes.
Okay. think I got my other questions answered. Okay, thank you. Oh, no, just one. So the 55 hours that you mentioned, that's the difference, the 55 hours of operation of the ICE, that's the difference between what the inspection of 2013 indicated and 2017 indicated?
Yes.
Okay. And you have not made any inspections since 2017?
I had a follow-up inspection, I think it might have been in March or April. I don't have that number with
Of
me, but I did.
2018?
Yes, I did verify that they were continuing to operate that engine.
And that, you verified the engine, did you also verify the boilers?
At that time, no.
Okay, thank you.
Mr. Camarena.
I have one more question regarding the school. Do you know how long it's been there?
I don't have the exact dates. I believe it was a newer school, about 2 or 3 years, but I don't have any exact dates.
Thank you.
Other questions? Senator.
You stated earlier that you're familiar with the stipulated order. Finding of facts, page 2, number 5, that's line 16. It talks about the purpose of the rule 1146.2 and the emission levels. And then you go to page 3, line 7 and 8, it talks about it again refers to the 15 years for the boiler. My question to you, that this, based on the adoption of Rule 1146.2, came after the fact as it relates to the boiler. And my question then, therefore, would the boiler have been in compliance other than the fact that 1146.2 was adopted, which makes it more stringent in meeting the requirements?
I don't think I understand the question.
If you measure the emission levels of the boiler, would they have been in compliance prior to the adoption of 1146.2? Because 1146.2 says 15 years is, then you're not in compliance. Is it because of the 15 years or because of the emission levels?
So the 15 years is a way to show compliance with 1146.2. Once it reaches older than 15 years, and there's other ways that they can show compliance.
Well, if it's more than 15 years, right away you're not in compliance, no matter what the readings are. Is that correct?
It can be a certified unit, and older than 15 years, and it can be in compliance.
It can't be in compliance. But in this particular unit, which is older than 15 years, right? Mm-hmm. Okay. And that being the case, they were still not in compliance. Is that what you're saying?
Yes.
You took, the measurements were taken.
No measurements were taken.
Then how do you know we're not in compliance?
Because they didn't meet the 15 years or certified or had a source test.
That's what I mean, is that the 15 years came after the fact.
The violation is a lack of showing compliance with the rule.
It appears here, then, therefore, that the attempt is to stringent the requirements to reduce the emission, which will give us cleaner air. And that's what it looks like is happening. I'm trying to find out from you, what was your thinking and what is the rules as it applies to that process?
If they replace the boilers, they would have less emissions from those boilers.
How do you know?
Based off of the requirements of the rule.
Okay, even though they may malfunction, they may not be better.
If they're on the certified list, which the boilers that they intend to replace them, they are certified to meet those limits.
But it also says over here that the district when disputes, cannot demonstrate the boilers were exempt from A4C. It said that the district does not have any certified boilers that they should replace it with.
We have a list of certified boilers.
Senator, where are you reading from so that we can be on the same page?
It says right here on line 8, page 3, as determined by the serial number, each boiler was older than 15 years. AQMD alleges and responded disputes that some were certified by AQMD and that the facility cannot. Huh? None were certified.
I believe they're talking,
Okay.
I
All
believe they're
right,
talking
okay.
about the 4 boilers at the facility, is that correct?
Yes.
Okay.
Okay.
Any? It would be helpful if we had a copy of the NOV, although we do not have to. Let's be clear with a stipulated order. We do not have to find a violation. Any other questions for Ms. Torres? Seeing none. Ms. Sue, do you have another witness?
Would you switch seats? Good morning, Mr. Baker. Would you please state and spell your name for the record?
Sidney Baker, Sidney Baker.
And did you take the oath this morning?
Yes.
And what is your title here at this district?
Air quality engineer too?
And how long have you worked in this position?
30 years.
Okay, and could you please briefly describe your responsibilities?
I'm currently in the operations unit, and we deal with permitting emergency IC engines and other types of equipment.
And have you reviewed the petition in this matter?
Yes.
And are you familiar with the respondent?
Yes.
Are you familiar with Rule 1470?
Yes.
And the rule provides emissions limits for internal combustion engines, correct?
Yes.
What is the emissions limit for non-methane hydrocarbon and oxides of nitrogen for engines with a horsepower of 175 or greater, but less than or equal to 750?
That emission standard is 3.0 grams per block horsepower hour.
Okay, and what is the particulate matter emissions limits for engines located 100 meters or less from a school?
0.01 grams per block horsepower hour.
Okay, and does the facility's current engine meet those limits?
Objection, lack of personal knowledge,
Or
lack of foundation.
Can you lay the foundation, please?
do you have knowledge of what the current engine's limits are?
Yes.
And how did you come about this knowledge?
The engine was previously permitted, so I accessed that record through our class system, and I copied the original permit, and it did have the block horsepower rating on that permit.
And what was the emissions limits based on these records for the current internal combustion engine at the facility?
For PM, it was 0.23 grams per block horsepower hour.
And what about the non-methane hydrocarbon and oxides of nitrogen emissions?
It was 9.79 grams per block horsepower hour.
Okay, and are there limits on when an engine can operate if they are nearby a school?
Yes.
And referring you to page 14 of Rule 1470,
Okay.
what are the time limits for operations of internal combustion engines?
On school days, it's 7:30 in the morning until 4:30 in the afternoon.
Meaning that they cannot operate during those times?
That's correct.
Great, thank you. No further questions at this time, Mr. Baker.
Mr. Stone, do you have questions for Mr. Baker?
Yes. You never personally inspected the internal combustion engine, did you?
No.
Have you ever been on the property?
No.
How did you come to know the block horsepower of the engine at the property?
That was based on the previous permit.
And I'm sorry, when was that permit filed?
oh, wait, hold on. I have a copy of it here. It was granted July 17, 2002.
Okay, so those are the last readings from, the last indications that anyone who inspected the engine observed.
I don't know about inspected, but that's when the permit was granted, so that was the information I gathered.
Okay, so nobody has inspected the units with regard to the emissions in 16 years?
I can't comment on that.
Okay. Do you know when the when the emergency internal combustion engine was being run on the property?
No.
So you don't know if it was running during school hours?
No, the inspector did not present any maintenance records or anything like that.
Thank you. That's all.
Just a quick question. When the district receives an application for a permit, where does the information regarding the equipment come from?
It comes from the applicant?
So the applicant itself gives that information,
Yes.
including emission limits?
Emission limits, block horsepower rating.
Thank you. And in your experience and your expertise, do you find that emissions generally go up over time as a piece of equipment gets older and more out of date or maintenance?
Yes.
Okay, thank you. Any questions for Mr. Baker? Thank you. Ms. Su, do you have any other witnesses?
No, that is all the witnesses from the district.
Sorry, Senator, no questions.
You just answered the question that, given the age of the equipment, the emission levels increases with period of time. Is that what you just said?
Yes, sir.
Okay. Well, you ever thought about there's a maintenance program associated with this equipment sometime?
There should be.
And so therefore, if that's employed and maintained, would it still retain the same level of emission?
It should, however, the inspector did not find any maintenance records for this particular piece of equipment, so we can't make that determination.
So there's no maintenance program that you know of?
Without any records, I'd have to agree with that.
So therefore, but then it's not necessarily a fact, assertable therefore, to when it's stated that due to the age of the equipment, the emission level is going to increase, notwithstanding the age,
However, the applicant,
notwithstanding the maintenance program.
well, the operator is supposed to keep maintenance records. That's how we determine whether or not the equipment is going to be in compliance or not.
Okay. So to your knowledge, there are no maintenance programs at the site?
That's correct.
Okay, thank you.
I actually had another question I forgot to ask, Mr. Baker. In accordance with the proposed stipulated order, one condition would be to submit a permit application for a retrofitted or replacement emergency internal combustion engine by a certain date. Would you be involved at all in that permit application?
There's a good possibility I would be. It would depend on the workload that's in the unit and my personal workload. But that would be left up to my supervisors.
But you generally deal with applications or permits of that nature?
Yes, yes.
Do you know approximately how much time it would normally take? I noticed there is no requirement of expedited processing.
As far as processing time, anywhere from 1 to 2 months.
For something like that?
Yes.
And would expedited processing really make much of a difference in that matter?
For this particular, okay, because the proposed location is within basically 1,000 feet of the school, they would have to undergo public notice, and that's going to add about 30 to 45 days to the actual permitting process.
But that's unavoidable regardless of expedited processing?
Yes.
So does expedited processing give you any real additional, or make it much quicker at all in this situation?
In this situation, in my opinion, no.
Okay, thank you. Senator has one final question.
Did I hear you say earlier that you've been here for 30 years doing this?
Yes, sir.
Okay, thank you.
Oh. We'll all keep thinking of new questions. Ms. Pert?
I'm sorry. Well, in respondent's opening, he mentioned something, I think, about the inability to retrofit. Is it your experience based on this equipment that it won't be able to be retrofitted? Or, I don't know if it was this unit or the boilers that he was stating.
I think he was referring to the boilers.
Okay. But that will also have to come through you. Is it, in your opinion, possible to retrofit the equipment that is listed?
Well, in my opinion, one like what's going to happen is the retrofit cost will exceed
Okay.
the cost of buying something new, and it's more likely to comply with our emission standards.
Okay, that makes sense. Thank you.
Dr. Lerner has a question.
Just for my own information, on the permit, is there a schedule for maintenance?
That would be a permit condition, yes, sir.
It is, and that maintenance is to be reported if it is in excess of what is permitted in terms of pollutants?
The maintenance conditions are more or less hourly conditions and not necessarily emissions conditions, although there is emission conditions on the permit. Because it's an emergency IC engine, the permit condition states basically that, the operator should not operate the equipment more than 200 hours any given year, and that's what the inspector will look for.
Thank you.
Any other questions? Ms. Sue, you have no additional witnesses?
No, I
Excuse me.
do not.
Okay. Mr. Stone, you may present your first witness.
Could we actually take a moment? I think also our other witness needs to be sworn in as well.
Yes.
Could we have a sidebar minute or two?
Yes, yes, why don't you I was looking at the time to see if we should take a break. Why don't we do that? Why don't we take a 15-minute break, and that way you'll have an opportunity to speak with your client. We'll be back on the record. We're going to go off the record and come back at 10:15. We're off the record.
benefits of the board.
We're back on the record. I understand there's one witness who has not been sworn in, so at this time, if you please rise to be sworn in. Please raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Okay, Mr. Stone, you may present your first witness. Oh, we're back to the not recording. We'll go off the record. Okay, we're back on the record. I do not need to re-swear in the witness, but when you present your first witness, Mr. Stone, just please ask her to state her name, spell it, state her title, and state that she took the oath today.
Good morning, Ms. Contreras. Can you please just state your name?
Yes, Nelida Contreras.
Can you spell that?
Yes, NELIDACONTRERAS.
And did you take the oath this morning?
I did.
Thank you. Please just remember, of course, to lean into the microphone and speak clearly into it.
And you can leave the microphone on, even when you're not speaking, if you'd like.
Okay. It's on.
Okay, Contreras, where do you work?
I work at Sheraton Townhouse,
And where is that located?
639 South Commonwealth Avenue in Los Angeles.
Is that in the middle of Los Angeles?
It is mid-Wilshire area, yes.
How long have you worked there?
8 years.
And how old is the building?
Oh, the building is approximately over 80 years, constructed in 1922. Yes, sir.
And is the building affordable housing?
It is. It's under the tax credit allocation committee.
Are you able to raise rents as you please?
No,
And the rents are well below market rate, is that right?
that is correct.
Were you working in the building when it was coming out of the rent escrow account program, which I'll just call REAP for the record?
Yes, I was.
And do you recall approximately how much money your organization had to spend in order to bring the building out of REAP?
Well, as far as I know, I've not seen the account numbers, but I couldn't comment exactly on that amount.
Is it more than $2 million?
I would say if everything that happened there during my time, certainly, I would assess that.
Were they very large capital projects that needed to retrofit the building in order to get it out of REAP?
Absolutely. We were on every floor in every apartment and every common area, interior and exterior.
And you were on the property when the inspector visited in March 2013?
That is correct.
You recall if it was March or April 2013?
I recall that it was April.
Okay. Do you remember what date in April?
Not precisely, but I do have record on with me if you need me to confirm that.
And was a citation issued, or excuse me, a notice of violation issued on that time?
There was.
Do you remember what the citation was for?
The boilers needed to be retrofitted or replaced and non-compliant, and the permit regarding the use of the generator.
Okay, so you think it was, do you remember precisely if it was the boilers at that time?
I do, yes.
Okay. And you say it was, a permit was needed for the internal combustion engine, emergency generator?
Correct.
And we're talking about the emergency, whenever we say the internal combustion engine, we're talking about the emergency generator. Do you understand
Yes,
that?
I do.
And do you recall what happened with that notice of violation?
I got on I got on it right away and informed my upper management and ownership, and got proposals in, and completed my due diligence in that sense, and also worked with the investigator at that time, Vega, I believe is the name, and for whatever reason, there were no follow-ups from inspector or the investigator, and I then assumed that it was all rectified.
Okay, let's move on to 2014. In 2014, did you have any large capital projects that needed, required a lot of money in the property?
Since I've been there, yes, quite a bit. The elevators was a major project. The fire pump, that we had to do a lot of retrofit there. It's an old building, so it needs constant care and repair.
Do you know how much money approximately the company has spent, or the organization has spent to modernize the elevators over the last couple of years?
Yeah, that's, I would say over 100,000.
Okay. Do you know precisely how much?
I don't, sorry.
Okay. That's fine. And do you recall the inspector coming to the property in 2017?
Yes.
And do you remember when that was?
December 5th.
And did you show the inspector around the property?
Actually, no, my maintenance staff showed her around.
Okay. Were you on the property when that happened?
Yes.
Okay. Okay, let's go ahead and talk about the notice we received in April of this year. Did you receive a letter in April from the Air Quality Management District?
I did.
Remember when you received that?
Believe mid-April, maybe April 12th or 13th.
And the letter was just following up on the violation that was issued in December, right?
Correct.
And what did you do when you received the letter?
I called my maintenance director and let him know that I received this letter, and we needed to get together and, clear and rectify this.
And what did you do with regard to the boilers?
We immediately got together and requested for vendors to come in on site to assess and submit proposals or bids for either retrofit or replacement.
And just for reference, I'm handing the witness the document marked Exhibit 1 provided to the board.
I also need a copy. Thank you.
Oh, okay.
Is it the letter that you're referring to?
Yeah, it's the April 18th, 2018 letter from council for Air Quality Management District.
Okay.
And do you recognize this document?
I do.
What is it?
It's basically a letter from
I'm sorry, hold on, we're going to mark this. Everybody has a copy, Miss Sue, you have a copy. We're going to mark this exhibit as Exhibit A for respondent. Thank you, you may go ahead.
Yes, it's a letter from the Senior Deputy District, basically letting me know that she's handling this case and that I should contact her no later than May 16th with a list of questions that I should provide information to her for or about.
Is there an attachment to that letter?
Yes.
What is that?
The notice of violation.
And is it the notice of violation from the December inspection?
Yes, it is.
And what do you understand the violation to concern?
I understand it to concern the permit violation for the emergency internal combustion engine and operating of the boilers without demonstrating compliance with emission limits.
Once you received that letter, what did you do with respect to coming into compliance as claimed by the violation?
I, again, took out old proposals to contact vendors that I had in the past and proceeded to get a work on them coming on site to assess or update their proposals from that previous date, and started to acknowledge the questions in the permit application, which I clearly didn't understand a lot of. So I got on the line with my maintenance director and we proceeded to work on it together.
Now, with regard to the boilers, were you able to get the process going for coming into compliance as claimed by the violation?
Can you repeat the question, please?
Yeah, were you able to get the process going for the boilers with regard to coming into compliance as claimed by the violation?
Yes,
And did you receive any bids?
absolutely.
Do you remember when that was?
That was approximately, let's see, a few of them came in later than other. I would say about right around the date of the notice from the deputy. So soon after.
Okay.
Yeah.
I'm sorry, can you clarify what notice you're talking
The
about?
notice is from the notice from the Senior Deputy District Counsel, Daphne Sue, or
You're talking about the April 18th letter?
Exhibit A.
Thank you.
And do you recall what the inspector said with regard to the emergency generators and how to come into compliance as claimed by the Air Quality Management District?
Yes, I was informed that at that time of their last visit, that I could not submit a permit for the, oh, sorry. Sorry about that.
Let's take this opportunity as a reminder to everyone to please silence your phones. Thank you.
My apologies. So, in regard to the permit, I was informed that I could not submit a permit for the application permit for the generator, the emergency combustion engine, till we had rectified the boilers on site. So I just looked at the questions and realized that I needed assistance and moved forward with that to proceed with getting information and research groups, consultant groups who can assist us with that.
Do you recall when you learned that you needed to replace the emergency generator?
I don't recall there being that suggestion to replace it.
Were you ever notified that something more than getting a permit for the emergency generator was needed?
No.
Have you taken any action to replace the emergency generator?
No, I wasn't given that information to replace it, just simply to submit application for the permit for use of the generator.
Have you received any bids or anything like that for determining what needs to be done with regard to the emergency generator?
That is scheduled for the June 18th to have a vendor come out, one of our vendors come out and assess that.
And when did you learn that something more, let me rephrase that. When did you learn that the Air Quality Management District required you to do something more than get a permit?
If anything at all, it's just very recent in the last week.
And then as soon as you were told that the Air Quality Management District was requiring something more than obtaining a permit, that's when you contacted some vendors and all that?
Yes, correct.
Okay. Okay, and is there a school within 100 meters of the property?
No,
Is there a school nearby?
there is.
How far away is it?
It's approximately 330 meters.
Okay. Did you measure it yourself?
I did.
Okay. Great. Nothing further.
Ms. Sue, questions for the witness?
Ms. Contreras, were you the community manager of Sheraton Townhouse back in 2013?
Yes, I was.
And have you been the community manager since 2013?
That is correct.
So you testified that you had received a notice of violation for boilers that were in non-compliance and also a requirement for permitting for the internal combustion engine, correct, in 2013?
Yes.
Okay. Since you received that notice, have you replaced those boilers?
No.
Have you retrofitted those boilers?
No.
Have you applied for a permit for the internal combustion engine?
No.
Okay. Have you ceased using the internal combustion engine?
No.
And turning to Exhibit A, the third page, did you receive this notice of violation?
Yes.
And around when did you receive this notice of violation?
On the date noted of violation, December 5th,
Okay.
2017.
And since you received this notice of violation in December 2017, when did you first call to receive bids about the boilers?
That was in 2013, actually. But since this violation, I brought out like I mentioned, old bids and contacted vendors to update.
And when did you contact those vendors? What date?
I would say about February, March.
Okay. And when did you also contact people regarding the internal combustion engine?
No,
I thought you had testified that someone is coming in June.
or, yes,
So when did you first contact them about?
about a week ago.
Okay, thank
Yeah.
you. And you mentioned that you measured the distance from the school to the building, correct?
did.
And from what point from your building to the school did you measure?
At the entry gate adjacent to the generator to the end of the gate where the school property line starts.
Okay. And could you tell us the route that you walked, or how did you?
It's a straight walk from the entry gate that's adjacent to the generator to the school.
And what did you use to measure?
I used 16-foot measuring tape.
Okay, thank you.
Okay, I'll start. Did you, okay, I misunderstood your testimony. I thought originally you had testified that you began looking into boilers and replacements and retrofits and bringing people on after receiving the letter that is marked Exhibit A. Was that correct?
That is correct.
Okay, because I thought in response to Ms. Sue's question, you had stated that you contacted vendors beginning in February or March, or did I misunderstand that?
I had contacted vendors throughout the time from the first violation and the second notice of violation. So that's a long time in between. But as far as the dates, I couldn't specifically state them. I actually do have a couple of proposals in my briefcase. If I could take them out, I could give you specific dates, but.
I'm just looking for timeframes, and the reason why is I just want to I wanted to get your understanding that it's your understanding, correct, that the facility, that Sheraton Townhouse, is itself responsible for compliance with district rules and regulations. Is that your understanding?
Yes, I am made aware, yes.
Okay, because I asked that question based on some of the responses, for example, regarding the fact that there was an NOV in 2013, you testified that you followed up and did due diligence, but dropped that because the district did not return for inspection.
Correct.
It is your understanding that regardless of whether the district shows up, knocks on your door, and enforces the rules, that you must comply, is that correct?
Yes.
Okay. I have another general question, that is, are you familiar with the proposed order for abatement? And
Yes.
the provisions?
Yes.
Are you familiar with the timeline that is in here?
There was a timeline generated, yes.
Is it your understanding that you, and in particular, not just you, the you, I mean the greater you of Sheraton Townhouse, intends to comply with the order as it is stated in the
Absolutely,
stipulated
yes.
order? Okay. I also wanted to ask a question, and I'm not sure if you're the person to answer, and I'll allow Mr. Stone to indicate who's the best to answer this question, because it is sort of legal, but, okay, the question is, when you agree to stipulate to an order for abatement, and if this board adopts it, we adopt it with the stated facts and findings, as well as the conclusions and the order, which has the stated conditions as well, and meant to bring you into compliance. There is a conclusion here on page 4, number 4, which has to do with the issue of due process of law. And by entering into this stipulated order, and by this board, should we adopt it and approve it and grant it, you would be agreeing that issuance of the stipulated order for abatement upon a fully noticed hearing will not constitute a taking of property without due process of law.
Well, if I may, I think that if you're asking the witness that question, I would have to object to a legal
That's
conclusion.
fine. And I will ask, it's a stipulated order.
Yes. No, we
I
certainly,
need to understand that Sheraton Townhouse is on board with this and will not be raising it as a defense in the future.
sure. I'm not sure we can agree that there was due process here, especially with regard to the violations for the 1470 and 222, which were not a part of the December 2017 violation that we're here for. Well, that was a basis for this petition. We can certainly agree to that with regard to District Rule 203 and 1146.2, but not 1470.
Okay,
and
well, this
222.
stipulated order that is before the board includes all of those. And so either we have the stipulation for the entire order or we are in a contested situation. And I think it would be good to know that right now.
Sure. Then I would propose that we modify or at least have some time to talk about it between council, to talk about the stipulation. Again, our client's position is that we're willing to get going on doing what we need to do to fall within compliance with the Air Quality Management District's requirements. As I stated in the opening, we do have some concerns about the timeline, especially with regard to the emergency generator being so soon, and we only received the amended petition as our first notice that we need to do something more than just obtaining a permit last week, and it's just simply not enough time. So if we are going to be pushed to say that that's a due process as part of this petition, as part of this hearing, we can't agree to that.
Okay, well, then we should probably stop here and consider how we're going to, I'll probably have to go back to the district then, because I'm not sure if you've presented a full case, if this is no longer a stipulated order. And I just want to be very clear that if this board adopts a stipulated order, it is an order. It has the full force of any district rule or regulation, regardless of whether it was stipulated to or not stipulated to. Once this board votes on it and it becomes an order, it is an order of the South Coast Air Quality Management District and can be enforced. Perhaps you did not fully understand that because it's not a try if you can, and if you can't, come back and modify. And we started the hearing with that very discussion.
Sure. Do you mind if we just take a moment? Maybe council and I can discuss this issue.
Would 15 minutes be adequate, do you believe?
That works for the district.
15 minutes? Do you need that much time? It seems like it's a pretty, it's a pretty important issue to discuss.
15 minutes will suffice.
Okay, then we'll go off the record then until 11 o'clock. We are off the record. We're back on the record. I'm not sure who, between Ms. Sue, Mr. Stone would like to start.
We'll move forward with the stipulated order as proposed.
Okay, excellent. And so I think where we were asking questions of Ms. Contreras. And just trying to see if I had any other questions. I think I'm good. Anyway, any other board members have questions? Dr. Lerner.
Point of information, since I was a kid, I grew up in housing projects, defense housing projects. I've also lived in rent control, thank God, in New York City in the 70s. What I'd like to know is if the costs of these boilers and et cetera that we are talking about now, replacing, repairing, et cetera, are those pass-through costs under the terms of the affordable housing that you're managing, or are these costs somehow absorbed?
These costs are absorbed, sir, yes.
Excuse me?
These costs are absorbed, yes.
Okay, so that the renters do not have to, good, thank you, that's very helpful.
Mr. Camarena.
Had a couple of questions for you, Ms. Contreras. We haven't seen the permit on the internal combustion engine, but Engineer Baker told us that typically the permit has conditions that require maintenance. Are you familiar with the permit on the IC engine?
Yes.
Do you know if it has such conditions?
Maintenance, yes.
Okay. Do you know if those conditions, that those maintenance requirements are carried out?
Yes.
How do you know that?
Vendors come on site and test.
So you have a third-party
A third-party vendor, yes.
Okay. And how often is that done?
There's an annual load bank test and a monthly exercise test.
In his opening, Mr. Stone made some statements that suggested that some of the due dates, some of the requirements in the proposed order might be a bit tight. Do you agree with that?
It's doable,
It's doable?
yes.
Okay, thank you.
Anyone else? Ms. Byrd.
Just for clarification, I believe you said you had been there 8 years?
Correct.
Okay, so that's somewhere around 2011. But the district says that the permit for the ICE went non-renewable, inactive in 2012. So you haven't had a permit since then, but it went inactive while you were there.
It went inactive while I was there, yes, and did not have that knowledge at that time.
You didn't have which
I
knowledge?
didn't have the knowledge of it being
Inactive?
inactive
So
when I
you-
started,
I'm sorry.
when I came on.
So you're saying that you're not aware of there being notices sent to you because the district sends billing?
Actually, the notices were going to 2955, which was the previous ownership. So a lot of the initial notices were mailed, and I believe that they do have that address on file.
Okay, so the permit information, you didn't have anything at
Correct.
your address?
Correct.
For the
that
equipment
time.
that's located at that address?
At that time, that's
Okay,
correct.
because usually the district, are you aware that usually the district requires a permit? Permits are kept on the premises of wherever the equipment is?
I was not aware of it at that time. Yes.
Okay. Okay, thank you.
Anyone else have questions for this witness? Senator.
You answered the question a number of times regarding the distance from the apartment house to the school, and you took the measurements, correct?
Yes, correct.
And was that in feet, inches, or what?
feet.
Well, the requirement says 100 meters. Did you convert that to
Converted
meters?
it. Yes, I looked up I looked up the conversion.
And how many meters was it?
330 approximately.
Oh, okay, so it was in the limit.
Yes.
330
Meters.
meters.
Yes.
All right. The requirement is 100 meters. Okay. Thank you. That's Sheraton Townhouse.
Yes.
Where's that located?
We're on the corner of Commonwealth and Wilshire Boulevard.
Commonwealth and Wilshire.
Mm-hmm.
Is there a park across the street?
There's the Lafayette Recreation Center, yes, and the California Superior Courthouse.
What is it
adjacent.
called?
The Lafayette Recreation Center?
Yeah, one that I built.
Yeah. Oh,
Now, next question. Is that, was this a hotel at one point?
it was.
When was
Very
the convert-
famous hotel, the Sheraton Hotel.
All right, I'm familiar. When was it converted to?
To apartments, winter of 98, 99.
98, 99.
They began,
okay.
they began a retrofit, or the conversion in 96 and finalized in 90.
I've got to let you know this. I represented the district at that time and approved the conversion. I don't know if it's going to make a difference in what I.
Do you feel you have any bias or that you cannot hear this case fairly?
Oh, I'm not. Of course, I can be objective.
Okay. Then there should be no problem.
Okay.
Okay, fine. Now, I got to ask some questions about the conversion, if you don't mind. It used to be single rooms, now is it apartments?
I'm sorry, can you
Is
repeat the question?
Are those units or they apartments, number one, or whether it, like the hotel, one bedroom?
They converted them to apartments, so yes, the drywalls went up and they had to,
How many units are there now?
138 in that one
130.
building.
38. Or they just for anyone or for senior citizens?
All households, multifamily.
Was it ever just for senior citizens?
I believe not.
Okay. The next question. The letter you received from the district, did you answer that letter?
I did not. I proceeded to work on getting the information, gathering the information for council, and then was brought to my corporate office, and later attorneys were brought in to answer.
Okay, now, how is it, the city performs inspection of the building?
They do.
Okay. When was the city last inspection?
Actually, the city was there, I would say, to my best knowledge, memory, shortly after the February, March.
They have annual inspections? Mm-hmm. And did they have any concerns about this equipment that was not in compliance?
None at all.
Did you show them the notice? Did they request to
did.
see it?
They didn't request to see it. The inspector said, oh, that's another jurisdiction.
Okay, you were in the REAP program.
Yes.
Why were you in a REAP program? You testified that you were in the REAP program.
When I came in July of 2011, the building was already in REAP. I helped with the management team, and 2 years later, that was lifted. That sanction was lifted.
Do you know why I was in the REAP program?
I didn't have the full information about that. I kind of walked into a hornet's nest at that time.
You know what the REAP program is all about?
Not entirely, to be honest.
You manage an apartment
I do.
and you
yes.
don't know the REAP program.
I was not familiar until I came in
But you've
that
been
year.
there, you've been there 8 years. You got to know what the REAP program is.
Yes, you're right.
So if they have it in escrow, you're saying that REAP is in escrow, is that correct? Before you got it. And you helped bail it out of escrow by making the repairs.
Yes.
Did the REAP program suggest the landlord didn't do what they're supposed to do in the city?
We were not the landlord that brought the building into REAP. We were the landlord that brought it out of.
Was when you came out of REAP and the funds were held in escrow, who the tenants were paying the rent into escrow? Was that, or do you know that?
No, some were, majority not.
But you're in good standing right now.
Yes,
And this new requirement to be with the borders and so on will not be passed on.
no,
How do you know?
no. We, as far as I know, the only rent that can be changed in any way is through rent control, the rent stabilization ordinance, on an annual basis.
So you giving at least me, I don't know what the other, the assurance that once you make these requirements, you're not going to request the rent control pass them through.
No, not to my knowledge, sir.
Okay, hold on.
Well, unless there's other questions, Mr. Camarena has a question for this witness.
The violation notice that was issued in March of 2013 did you receive that?
Yes,
Were you the one that stated that the equipment would no longer be used?
no, sir, I am not.
Who did?
I have no knowledge about that. I was surprised that that was even on the record.
Okay, thank you.
Anyone else for this witness? Mr. Stone, you have another witness.
Yes, just a few questions for Ms. Galvez right here.
You can have Ms. Galvez state her name, spell it, and indicate that she took the oath today.
What's her name?
Rocio Galvez.
Can you spell that for me?
Yes, Rocio. Last name Galvez, Galvez.
And you took the oath this morning, correct?
Yes.
Ms. Galvez, you've heard the testimony of Ms. Contreras. Is there any areas that, is there anything else that you feel needs to be testified to?
Before you answer that, Ms. Galvez, I forgot to ask Mr. Stone to ask you your title.
I am the district supervisor with the management company.
Thank you.
What do you do as the district supervisor?
I oversee the properties. This is one of the properties that it's in my portfolio. I came as a district supervisor about 2 years ago, and Sheraton is one of my properties. So I am helping Nelida and the property go through this process and fix the situation.
Have you been involved with contacting the contractors and all that?
Yes, I am helping Nelida get bids and communicating with ownership to make sure we get the approvals and the necessary bids and pricing to get this done.
Do you have anything, has anything not been said regarding the contractors, anything like that?
Objection vague.
Okay.
Can you be more specific as to what areas you would like Ms. Galvez to cover?
Sure. With regard to the bids and the contractors being brought on the property, is there anything else you'd like to supplement other than what Ms. Contreras already testified to?
Objection vague.
Do you have any specific questions you'd like Ms. Galvez to answer? In particular, is there information you believe Ms. Galvez has to offer?
No. I think it's okay.
Okay.
That'll be all for us.
Okay, so then, since Ms. Galvez did not offer much testimony, I don't think we have questions for her. Okay, and Ms. Sue, you don't, I assume?
Good morning. There's no,
Oh, I'm sorry. I was asking whether you had questions, but let me, before you start your closing, Is there any member of the public that wishes to be heard on this matter? And seeing none. Now, Ms. Sue, I apologize.
There is no constitutional requirement or other requirement that the district issue a notice of violation prior to bringing a petition for order for abatement. The facility has admitted receiving the amended petition. It has stipulated to the proposed order. Ms. Contreras admits that it was cited in 2013 for similar violations, but has still not, 5 years later, come into compliance. She also testified to measuring the distance from the generator to the front gate of the school. She did not mention what the distance is from the generator to the nearest property line of the school. This facility has shown a relaxed attitude, to put it in the best light, towards compliance. And in order is necessary to bring the facility into compliance, we ask that the hearing board enter the stipulated proposed order. Thank you.
Thank you, Ms. Sue. Mr. Stone, you're closing.
We heard evidence today about several violations, two in fact. One back in 2013, it was a sole violation. I believe the inspector testified that it was only about the permit for the internal combustion engine. And you heard from Ms. Contreras that she immediately began to do work to get that remedied, but without further guidance from the inspector, the work just fell off the map. And Sheraton Townhouse acknowledges that it has an ongoing obligation to abide by the law in every respect, including the district rules. Notwithstanding that, we are here today after the second violation was issued in December 2017. Sheraton Townhomes is an affordable housing community with limited resources. It doesn't have a lot of resources to raise money. It can't just pass on the rent to the tenants in the property. Pass on the expenses of capital improvements, such as the work required by the Air Quality Management District to the tenants. But notwithstanding that, it is doing everything it can to remedy the citations issued by the Air Quality Management District. And again, there's been a lack of showing by the Air Quality Management District that sufficient notice was issued. We heard from, and we saw the notice of violation from December 2017 that had the notice of violations for violations of District Rules 203A and 1146.2. There was not violations noted for 222 and 1470. The Constitution provides that there cannot be a taking of property without due process of law. That's included in the same reason why notices would be issued in the first place, giving buildings and managers such as Sheraton Townhouse an opportunity to remedy the violations before imposing a sanction on them. That was not done with respect to District Rules 222 and 1470. And when we asked the inspector why she didn't have an explanation, and we didn't receive any notice that these violations were claimed by the district until they filed an amended petition on June 1st. And notwithstanding that, we got to work immediately. The client has contacted contractors in order to get bids. Nobody could show up before we had this hearing, less than 2 weeks after the amended petition was filed. The next contractors will appear at the property on June 19th. Even if we had more time, if this was part of the original petition, we probably would have had time to get the contractors on the property. But because it was part of the June 1st petition, we didn't have that time. Again, notwithstanding that, Sheraton Townhomes is willing to come into full compliance, and it believes that the timeline outlined in the stipulated order can be done. With that being said, Sheraton Townhouse does stipulate to the stipulated order. And it just as a further note, Air Quality Management District has not produced evidence to show that it violated the more extensive rules on the school that they allege to be within 100 meters. The inspector who visited the property did not measure. She used Google Maps, which is a technique that she claims is commonly used in the industry, but did not measure it herself. Ms. Contreras has been on the property for 8 years, and she measured the distance between the closest school, and it's 330 meters, and she did it herself using a tape measure. Thank you.
Mr. Camarena, would you like to begin the discussion?
Yes. This respondent has been in violation of a number of district rules for quite some time. Mr. Stone offered an excuse of out of sight, out of mind, because the district did not follow up on a notice of violation issued in 2013. Ms. Sue pointed out that the respondent has apparently has had a somewhat relaxed attitude regarding compliance, and I agree with that. But I'm disappointed that the district also appears to have had a somewhat relaxed attitude. What I was able to piece together is that after the violation notice was issued in 2013, there was a statement made by someone at Sheraton Townhouse that the IC engine would no longer be used. And apparently there was no follow-up to verify whether or not that was in fact the case. And looking in the district's facility information detail find, it shows that the matter was closed, case was closed in November of 2013.
Mr. Cameron, if you want to introduce something off a fine that was not introduced into evidence, we should take a moment and make it a hearing board exhibit unless you do not want to or don't feel you need to refer to it.
I don't feel I need to. I think we have a stipulation. The respondent, Ms. Contreras, testified that the requirements in the order are doable, and I'm satisfied with that. I was just reviewing some of the reasons for my dissatisfaction with respect to follow-up on notices of violation. Thank you.
I believe, as I believe Mr. Camarena does as well, that there is good cause for an order for abatement at this juncture, given the longstanding violations, how long all of these pieces of equipment have been out of compliance, the long gap between the NOV in 2013 and the more current one in to the end of last year, 2017, and the overall attitude of if I'm not being forced to do it right now, I'll just let it go. I think for sure gives us good cause to move forward with an order for abatement, and particularly one that certainly has the timeline moving quickly in terms of obtaining the financing and putting in applications for permits for both the boilers and the ICE emergency engine. I have concerns. I would never vote in favor of a stipulated order for abatement unless I believe that the parties are on the same, they have a meeting of the minds, they're both on board in terms of the stipulated findings and decision and conditions that are contained within this document. I understand that with a stipulated order for abatement, it is not the responsibility, or you do not have to legally agree that you are in violation. However, the stipulated order, which we will vote on soon, specifically says that you continue to deny it. But the one thing that it does say, and I want to be very clear, because we adjourned and came back on the record, that there is a conclusion, and if we do approve and grant this stipulated order for abatement, that it is, that the parties are in agreement that their due process was followed in this case. It says so here, and that is under that condition with which the board would vote to include it, because we do not approve things that will later be challenged on their face. But I believe that the parties came back and agreed to that, regardless of whether there was hedging in the closing. The final thing I would say is I would like to ask the parties, since it's a stipulated order, we need agreement of both parties. I have concerns about, on page 6, with condition number 11, with regard to completing the retrofit or installation of replacement emergency internal combustion engine within 21 days after issuance of the permit. The next sentence, which reads, if respondent finds it cannot meet the 21-day deadline to complete retrofit or installation, it may petition the hearing board for a modification of the order pursuant to Regulation 8. The reason why I have issues with that is it is something that is always, as I stated in the outset, respondents always have that ability to petition for a modification and show good cause for that modification. But I worry in every minute order, there's a particular date by which that any kind of request like that or request for modification must be made before an order ends. And I worry that might be in conflict. And so I wouldn't want there to be an argument that there was some kind of allowance beyond the timing or the time frame that is allowable, given how long this order is to be in effect. So if the parties are in agreement, I think it should be removed, but understanding that we're not taking away anything you do not have a right already to do. So I guess I'll begin with Mr. Stone, since I think Ms. Sue would probably agree. It's not a provision that I understand she negotiated to be in there. And we understand as a board that hindsight is 20/20, and we understand you're making your best guess, and we understand that things may happen. Now, go ahead.
I think it'll be okay.
To remove it?
To remove the, if respondent finds it cannot, sentence starting on line 2 of page 6.
And it's to understand, it's simply because it's superfluous and could be in conflict.
The district has no objection to its removal.
Okay. That's all I have to say in deliberation. Ms. Byrd.
I have very little to say other than Ms. Contreras said this is doable, and we're going with that it's doable. I think there were some, I will like to say one thing, and that is just because I know there's a statement that ignorance of the law does not mean that you don't have to comply. And I just got the feeling, even with the district not following up, that this was a case where it wasn't understood, things are not understood, but you're still responsible. And so that's all I have to say. But she said it's doable. I'm going with it's doable.
Anyone else wish to comment? Senator?
Page 2. Number 7, order, line 19. We can complete inspection of emergency internal combustion engine by June 19th.
Sorry, are you looking on the, what document are you looking on? Are you
All
looking,
stipulated.
page 2?
I'm sorry, maybe this page, I'm sorry, page 5, I'm correct.
Okay. And what line, so that we get reoriented?
19,
19.
order number 7. Who's going to perform this inspection?
We closed the hearing,
Okay, well, fine.
but I do believe that
question
there was testimony that on the 18th, they have a consultant coming in for this purpose.
Yeah, but my concern is the same as yours, under 21 days, because the inspection got to come before the 21 days. If it doesn't, they don't meet that.
The 21-day is found in condition 11, which is the completion of the retrofit or the installation of a replacement emergency internal combustion engine, whichever they have found they can do or need to do, but that is after they've received the permit. So that is separate from the condition that you're referring to. The condition you're referring to has nothing to do with 21 days. It's a date certain that by June 19th, they have to complete that
But
inspection.
it's also, number 7 is to determine whether a retrofit or full replacement will bring it into compliance. And if it's determined that it can bring it in compliance in 21 days, then it's moot.
No, that is to determine whether it is a retrofit or a full replacement. What will enable them to bring the engine into compliance? And that inspection is going to be made by June 19th, and the testimony was, in fact, scheduled currently for June 18th, but by the 19th, that should be done. Once that's done, then the other conditions follow. They will obtain bids and financing by July 6th. They will submit a permit application, provide public notice because of the school. Then, within 21 days of receiving the permit, they have to complete the retrofit or installation, whichever they've determined to do.
So what they have to do is get a bid, borrow the money. They also said they have to go ahead
By July 6th.
and borrow the money for full replacement.
Either
Okay.
retrofit or full replacement.
Right. So all those things must be done before you get to the point where the 21 days will trigger.
All those are done before they have to put in their permit application by July 13th. And then that starts the district, and we had heard testimony from the district that it would take about 1 to 2 months. And then taking into account that there's a 30 to 45-day public notice period as well. And once that is completed and the permit is given, that is when the 21 days then for the completion of retrofit or installment comes into play.
Then it's being approved based on the condition probability, the likelihood of all these things happening before the 21-day requirement is triggered.
No, the 21 days is triggered once they receive a permit. But yes, everything else will have happened before they can
Take
apply.
place first. And then you get to line number 7, where it says the hearing board shall retain jurisdiction for 1 year. Now, if they get tripped up along the way and 1 year elapse, and it could do that because the district don't go out and do due diligence. They don't do inspection, they let it lapse for a period of time. And when the year runs, there could be a problem if they've not met all those conditions.
I don't see that because in here there are dates certain by which they have to do it. If they don't do it, they're out of compliance in violation of the order. All this should be able to be done within a year. And if there is an issue, and if there is this trip up, then the facility would have to come and request a modification. And at that time, we would extend our jurisdiction. But the year jurisdiction seems, to me, I don't know, it's open for discussion, seems adequate for what we have before us.
You extend jurisdiction if the district does what it's supposed to do in order to check and balance, and then discover they didn't comply with the dates, et cetera, then the district come back and say, oh, we're gonna cite them, and then they come and ask for modification?
If they
How does
did,
it work?
let's just be very clear. It is the responsibility, and I think we've all been hammering this, because we've been hearing that this facility does not feel perhaps it is their responsibility, for whatever reason, to comply with the law if the district is not out there enforcing it. That is not correct. It is the facility's responsibility to comply. If the district isn't following up and doesn't find out for, however long from now that it wasn't complied with, they can still enforce it and bring an enforcement action for a violation. Because as we said before, if this order is granted, it becomes an order of the board, it becomes an order of the South Coast Air Quality Management District on par with rules and regulations that must be complied with or violations.
Okay. Is an aside, additional information, if I'm permitted to say so. We did talk about this being a hotel previously. And the Sheraton Hotel was #1 on Wilshire Boulevard until the Central City Hotel was built. And it's always been I did raise the question whether or not it's for senior citizens or just open to the general public. I did ask that, and it was responded to. Initially, it was senior citizens. Okay? And in order for this project to be accepted into a REAP program and money going to escrow, somebody destroyed the property. And sad to note that that's really what in fact happened. I should have asked, but I didn't, whether they had a training program for the new tenants coming in. Because you don't go into the REAP program unless that in fact happens. They destroy the property. Anyway, good luck.
Anyone else? Dr. Lerner?
Yeah. I need some help from the board because we basically are discussing this. I thought I heard testimony or comments by the respondents that there would be no pass-throughs in terms of costs. But then I heard the attorney in his closing said there would be pass-throughs. Am I confused? And you guys, perhaps you can all explain that to me.
Yeah, I didn't hear that. But as Ms. Bird is indicating, we need to base our findings on the evidence, and the evidence was through Ms. Contreras, I believe.
Yes.
Testimony with regard to that there are no pass-throughs.
There are, okay.
Not the attorney, and the attorney, I don't believe he said that, but if he did, it's not evident.
Well, that was my problem. I think I misheard him. That's why I'm asking. Yeah, I think we need to do this, and I think it's very important, not only for the air pollution issue, which all of us are involved in, but also to make sure that these people can continue to live in that residence within the law. And it's the management's responsibility, of course, to be in the law, whether the district sends its inspectors on a timely basis or not. Those are the set of rules they need to be abided by. I think this is a good stipulated order, and I think I am in agreement with the whole concept of getting it done and getting it out of the way and moving along quickly.
And Dr. Lerner?
I'm sorry.
No, I just wanted to point out that even if it was a pass-through, and I don't believe that it was, but the witness said that this is doable. So that gives me a different feeling for the whole thing. Obviously, have some way of determining that they can pay for what they need to do. She said it's doable. This is doable. This order, as it stands, is doable, so.
I hear you. Thank you, Pat.
Anyone else? Would anyone like to make a motion? Otherwise, I can. Okay, Ms. Byrd.
In the matter of case number 6106-1, Sheraton Township, Sheraton Townhouse, I move that we issue the stipulated order with the following changes. On the first page, in the caption and the footer, to remove proposed. And then on page 6, beginning on line 2, continuing to line 4, to remove the sentence that begins, if respondent finds it cannot meet the 21-day deadline. And I believe that's it. Let's see.
I'll second that motion.
Thank you, Mr. Camarena. Any discussion on the motion? Seeing none. Senator, how do you vote?
I vote aye.
Senator votes aye. Dr. Lerner?
Aye.
I vote yes. Ms. Byrd?
Yes.
Mr. Camarena?
Yes.
Motion passes 5-0. And again, I know we've said this a number of times, but this order is now same as a rule or regulation of the district, and we expect it to be complied with. And should the respondent want or seek a modification at any point, we'll have to prove good cause for that modification. And with that said, thank you very much. Any other business board members? Seeing none, we are adjourned.